SJC-11578, in re Nathaniel Fujita.
Yes, counsel, good morning.
May I please the court? My name's John Albano. I'm here with Dina Malawani, who abandoned me in my time of need.
She's back there.
The trial in the case below began on February 11, 2013. On February 26, the Globe filed a motion to obtain the jury list immediately upon entry of the verdict. The verdict came back March 14. Pardon me. The motion was filed on February 26. The jury came back on March 7. On March 14, 7 days after the verdict, a hearing was held on the Globe's motion. On March 26, 1 month after the Globe's motion was filed, the court ruled that it would send letters to the jury asking if they were amenable to speaking to the press. And on April 16, now we're 1 month after the verdict, the court provided the Globe with the names and addresses of 2 jurors who wrote back saying they were willing to speak to the press. And those names came with instructions to use this information only for the purpose stated in the motion and not to disseminate this juror information to other news agencies or to third persons.
Could I ask you this? I understand that timing is one, but only one of your issues. But on that timing, I mean, the judge said later, you know, if this came up again, I would do what I did. I would probably give a letter, or I might give a letter right, you know, as they're leaving the courthouse. I assume, but this is what I wanted to ask you, is there some period of time that you would say, you know, obviously the judge has got to, this is not there needs to be some weighing, maybe you'd say, and so some period of time where the judge has to reflect on what he or she is going to do. And so what is that period of time?
Yes, our position is not in any way intended to convey the notion that the Superior Court has to stop what they're doing when a member of the press files a motion. That this appellant is completely content with and raises no objection to the manner in which the motions are disposed of and ruled upon by this Superior Court judge, or frankly any.
But isn't this amount of time, though, you do object to that?
That's a separate issue, it seems
Okay.
to me.
Okay.
It's not a question of please stop what you're doing. And that issue is this. It seems to me the key case analytically here is, although Silva's important, the first press enterprise case. We know from the first press enterprise case that jury voir dire is presumed open as a matter of constitutional law and that jurors' names are presumptively public.
And that happened here. There was an open voir dire.
Correct.
So if the Globe was in attendance, it could have heard whatever any member of the public could have heard. And
True.
so the press enterprise,
I would say press enterprise is quite helpful on this point because it means that you can't reconcile that holding with the notion that the names of the jurors are private.
well, were the names of the jurors made public at the voir dire proceedings, the juror selection proceedings?
I don't know the answer to that, Your Honor. I do know that there was discussion at the motion session about the fact that if there was a request for the jury voir dire, there would have to be redactions of the transcript to reflect certain private matters spoken of during the voir dire, which makes
May
perfect...
not have been done in public, or were they?
I do not know. I don't have the transcript. The transcript would have had to have been redacted. Let me, if I may, come at it this way. It seems to me this procedure makes sense. The alternative is file a motion ask to be present at all parts of the voir dire, make sure that the jurors object if it's juror number 15, no, we have a right under press enterprise to know, is that Susie Jones or not? And alternatively, allow the jury selection process to proceed. Do not request a list of the jury while the case is pending. Do not request a list of the jury list while the jury is deliberating.
No, you're suggesting you could make that request, but you're suggesting that it needn't be allowed.
Yes, and
While
this
the jury
movement,
is deliberating.
this movement, for these reasons, did not make the request for the jury list until, well, we made the request
Exactly.
before the verdict came back, but we asked to be provided with the jury list upon entry of the verdict. And so we're at that moment, the entry, I think the constitutional and common law concerns with delays beyond the entry of the verdict are twofold. One is, it unnecessarily invites trial courts to delay based on their personal preferences about the wisdom or lack of wisdom of juror interviews. We know that because the Massachusetts Jury Trial Bench Book recommends that judges consider temporarily delaying access to jury lists after the verdict and says, quote, such a delay may reduce the newsworthiness of any jury stories to the point where the media may no longer desire to seek out jurors for interviews or comments.
So if I understand you correctly, if I were to ask you, do you agree that there are any circumstances in which a juror's name should never be divulged to the media or publicly? Your answer would be no. There are absolutely no circumstances.
No, Your Honor. Silva, not that it matters what I say, but Silva was correctly decided. There was a threat to.
In Silva, you would say, I want the list of jurors and their names, and I want that confirmed during the jury selection process.
No.
No.
That's what you just said, didn't you?
I hope not. What I would present the motion, I consider that to be helpful to the court, to present
File
the
the
motion.
motion I am going to ask for.
Yes, during the course of the trial. I mean, the idea here is don't wait until the day before the verdict's coming back or when the jury's out to show up to the Superior Court and say, hey, I have a motion, I'd like the jury list. I'm trying to get the motion in early and say, but I don't give it to me until the verdict comes back.
Where is your entitlement? I mean, the press essentially is saying, we don't really want to spend the time to sit in during voir dire, so we would like you, Judge, to tell us the key information which we want, which is the names of the jurors and the addresses of the jurors, which, by the way, is not even mentioned at voir dire. That's information that's not contained, that's not generally presented at voir dire, that's not even presented in the jury questionnaires. So where is the press's entitlement to be able to have the simplicity of saying, we want to save time, times are tough in the press, please give us these names because we don't want to invest the time to be present at voir dire or to be asking for a transcript of the voir dire?
I think it would be a problematic request if the fact of the matter was not that for almost 200 years, jury lists have been part of the judicial record. They are part of the case file.
It's not part of the case file. If it's part of the case file, you could go to court and you could grab it. It's not docketed. It's not a court record.
Your Honor, we cite a study done by the Supreme Judicial Court's, let me get the name of it right, about 10 years ago, that made findings that case files from 1859 to 1959 were studied, and the vast majority of them had jury lists.
Well, they contain
that
them.
listed-
They contain them because the court officers need to be able to reach the jurors, but they're generally, as best as I can figure, obtained from the jury questionnaires, which are themselves, as a matter of statute, confidential, or by asking the jurors where they live and give me your telephone number so we can reach you in the event of an emergency. I mean, why is this not like Winfield, a case, by the way, which you never cited? It's a court record. It's in the property of the court. but it's not a public court record. There's no impoundment of it. It just is something which is created for the sake of the case and which you may get, but you have no entitlement to.
It seems to me, I'll tell you why I didn't cite Winfield. I honestly don't see how it bears on this case. I understood Winfield to be a case based on the concerns about electronic recordings of testimony, in that case, a rape case, involving sensitive matters that is the backup tape used by the court reporter. This motion is based on a request for a document that is part of the case file. The common law right of access is triggered by documents in the case file. Fair point, it's not docketed, Your Honor. But in terms of the concerns that this motion is based on, is docketing really? I would suggest docketing is not the key.
So you're saying, are you saying that the statute which says that the jury questionnaires are confidential is unconstitutional?
No, Your Honor.
But this information, apart from the name, which is mentioned in open court, the addresses would have to be derived either from the jury veneer list, or the questionnaires only contain the address and zip code.
The addresses.
I mean, the town and zip code.
The addresses, I can separate the two. The names, it seems to me, are, I would just submit there can be no compelling privacy interest in the names of jurors when the United States Supreme Court has said that the jury selection process, including the names, is presumptively public. As to addresses, the legislature has said that the addresses of the entire veneer are a matter of public record, Section 234A, Section
Right. So
60.
you can, as a matter of the press, you can sit down in voir dire, you can get a transcript of the voir dire, and then you can go to the court and figure out the address. Why is it a judge's constitutional obligation to make it simple for the press to reach out to jurors who don't want to be reached out to?
Well, of course,
know
we
that.
don't know if the jurors don't want to be reached out to or not, including in this case. There is, and I want to get to your question, can I get to the second half first, if I may? Here's the problem with resting on this kind of polling of the jury, would you like your names to be released? And I think this is a legitimate concern. Judges come in at the end of a trial and are entitled to and have been advised by this court to talk to the jurors and say, please do not disclose the contents of your deliberations. Entirely appropriate instruction to give. People may call you, please don't do that. Now, let me shift gears. Would any of you like me to give your names to the press? Well, that is not a fair way of determining whether a juror is, in fact, willing. There is, I think the court can take judicial notice of this. In Worcester last month, there was Commonwealth versus Corey, a decision denying access to a jury list said every member of the jury said they don't want to talk to the press. Interview published by the Worcester Telegram the next day of a juror who obviously did want to talk to the press. So we don't know.
Well, I understand, but of course, but in terms of the court's interest, judges tell a jury, please don't disclose what goes on in deliberations. The press wants that information after a jury verdict precisely to do just that. So why should we help you to do what you can do yourself through being present at voir dire, getting a transcript? Why must we essentially go out of our way, pluck out information from the record or information that we've gotten from the jurors for the purpose of being able to contact them and say, here, we're going to give you, members of the press, information for a purpose which we don't want you to actually do?
Your Honor, there's so much more to be discussed with a juror than the contents of deliberations. And the First Circuit decision in the Hurley jury list case listed them. There is discussion about, I think of it this way. I have heard many Superior Court judges talk about what they have learned by speaking to jurors after a trial, how it has confirmed their confidence in the wisdom of the jurors and in the system. That is a benefit that I suggest could be extended beyond Superior Court judges. There are volumes of issues to talk about other than the contents of the jury deliberation. And it does seem to me that if as a either common law or constitutional matter, the court, and obviously it's this court's decision, decides that there is a value in these communications. That is why the First Amendment protections exist.
Well, you say First
If-
Amendment. I mean, the federal statute doesn't even require the federal district courts to make it public. It's in the discretion of each district court.
That case, the First Circuit held that that statute should be interpreted in light of the First Amendment interests that are involved when this type of a request is made, and that there must be special circumstances present for a judge to deny in the federal system. If we go down to the waterfront, there must be special circumstances there, and juror preference, the court held, is not enough.
Right, I understand. That's what Globe said, but because the Massachusetts plan provides to allow them to be public, except when the interest of justice otherwise. But many district courts do not make it public. And are you aware of any federal case which has said that statute is unconstitutional, 28 U.S.C. 1863 B7, by not requiring it to be made public?
No, and I would hope there would be none. I am not here advocating, this party is not advocating that it must be made public.
I understand,
that there can be no
but
exceptions, and that's all that statute says.
Well, the statute permits it to be confidential. The Massachusetts plan says it's confidential only where the interest of justice so require. But other states don't have the interest of justice exception. The other district courts don't.
I don't know that, Your Honor. I'm sorry, I just don't know that. I do know, for example, the Fourth Circuit has held there is a common law right of access to jury lists, and other courts have held that there is a First Amendment right of access to jury lists. If we say this is a public, I see my time is up, forgive me. I would just conclude by saying we say this is a public process, and we know it is a public process, that it is at best a mixed message to say, hello, we are open to the public, but try and find us. Come up, stay for the voir dire, see what happens. Yes, we have the list here, which there is no compelling privacy interest in, but we shall not give it to you. And one unintended consequence, doesn't it drive people to look for juror names elsewhere? This is, I would conclude by saying, the procedure that's proposed here is a sensible and fair one. There is no information about the jurors' names requested prior to the verdict being returned, but when the verdict is returned, that information is made public. Thank you.
Good morning. Assistant Attorney General Eva Badway for the Middlesex Superior Court. The trial judge did not abuse his discretion by making public only the name and address of each trial juror who informed the court that he or she would be willing to speak with the media.
Let's take a step back, though.
Okay.
The identities of jurors, public information? The identities of jurors, public information?
To a certain extent.
Well, when are they not?
So there is a long recognized common law right to judicial records. And in Silva, this court assumed without deciding that the juror list is a judicial record.
Well, if I went to a voir dire hearing and
Yes.
watched a jury being impaneled, would I learn the names of the jurors?
I don't know, Your Honor. It depends if they refer to the jurors by number.
I might not, in other words.
Correct, Your Honor. In certain circumstances, you might not learn the name of the juror during
But
voir
I could
dire.
have the venire list,
That is correct.
and I could try to guess what their numbers were or something?
That is correct, Your Honor. If you do participate, I mean, if you are watching the voir dire and you do have the venire list, you can try
To
to
guess.
guess who matches up with who.
So you're saying go to the venire, going to voir dire, the empanelment will not necessarily get you the names.
That is true. It might not necessarily get you the names, Your Honor.
So is there any other way, as a member of the public, I should be able to find out who's on the jury?
Your Honor, in most cases, people, in the federal constitutional context, if you're saying that the juror list, the names of the venire are all public, okay? But there is no constitutional right, First Amendment right, to
To know
have
who
the
the
names.
jurors are?
No, Your Honor, there is no First Amendment right to that. In Massachusetts, there is a common law right to judicial records, okay? And in Silva, this court assumed without deciding that the juror list that's kept, as Judge Gantz characterized it, was a judicial record.
In the, our courtroom, cameras in the courtroom rule, you're not supposed to take pictures of jurors' faces either, are you?
That's correct, Your Honor.
And oftentimes judges in communicating with the jury, or if a particular juror has a problem and they want to discuss it on record, they refer to the juror. Well, I mean, I'm not saying that they do this all the time, but more often than not, if a juror has a particular problem that needs to be discussed with the judge and it's done in the open courtroom, the judge refers to the juror as juror 4-10 or something like that, whatever panel and seat number.
That is correct.
They don't refer to them by name typically.
That is correct, Your Honor.
Well, would you agree with me that there is a presumptive right to know who the jurors are or not, under our common law?
I would agree with you, Your Honor, that there is a presumptive right for the public to know who the jurors are under our common law.
Okay, so we have that presumptive right.
That is correct.
How does it get outweighed?
Well, here, I would point to the judge's decision, which was a very thoughtful analysis.
Was it really thoughtful?
It was thoughtful.
well,
Judge
they
Laurie
don't
had
wanna-
Judge Laurie had a discussion with the jurors during his discharge, and he told them that they had a right to speak with the media, and at that point, none of the jurors indicated a willingness to talk to the jurors. And I would
So
point
what
out,
outweighed the presumption was, I don't think the jurors want to talk to the media, therefore the presumption that the public should know is outweighed. Is that the balance?
no, Your Honor, that was not the balance. I would say that Judge Laurie had presided over a 4-week, very media-intense trial, and he actually noted that in his decision, that the media coverage of this trial was extensive. And if you go back and if you look at the docket, there were many motions by the media about access to certain records.
Right, but his discussion wasn't about that.
That's correct, but his analysis was about there was media discussion, and he noted that one of the jurors was in fact present during the sentencing and was sitting in the public gallery and was available for the press if the press had chosen to approach that juror, and they did not.
But why, how does that go to balancing? I mean,
Well, I think what Judge Laureate was saying was that in the course of the trial and the extensive media attention, he thinks he should give the jurors the ability to decide for themselves if they would like to talk to the press. And he thought the best way to facilitate that
no,
was
okay,
to write a
let's
letter.
stop there, though. Okay.
Okay.
He thinks that he should give them the right, but isn't that the issue, whether that's an appropriate factor, what they want to do, as opposed to, are there reasons why the presumptive openness of these names should be overcome in this case? Maybe safety, I mean, as in Silva, or maybe something else. But I think that the issue is it really appropriate to use as a factor an individual juror's preference not to speak to the media, which of course the individual juror could say to the media if ever approached. But isn't that the question?
No, Your Honor, I don't think that is the question. I think he did a balancing of all of the interest and the media attention that the trial received, and he had the discussion in the room with the jurors when he discharged them, and he asked them if anyone there was willing to speak to the press. and they did not indicate that they were willing. And it was because of that conversation that he thought that the best next step was to do, implement the process of sending the letter.
But doesn't that mean that the only thing that gets weighed is what the jurors want?
Or prefer?
I would say that it is one of
But what
the
you say
factors.
one, but what else was there here?
I think the fact that this was a media intense trial.
Okay, you've said that, but I don't understand what that has to do with the price of anything, you know? I mean, that it was media intense
Well, I think when
means-
jurors are discharged, they expect to go back to their private lives without being bothered. I mean, these people are not volunteering to serve.
No, I appreciate that.
They are there, and they were under intense scrutiny for 4 weeks, and the judge was able to observe that intense scrutiny, and he had a conversation with them at the end of the trial, asking them about their willingness, or indicating that they were allowed to speak to the press, and none of them took him up at that opportunity. So
When you say the jurors were under intense scrutiny, you mean they were present? What
right,
kind of
they're right.
they were
The whole
present?
trial was under intense scrutiny.
Now, there is a procedure for an anonymous jury
Yes.
in mob trials and other cases. That was not done here.
No, Your Honor.
And indeed, the names of the jurors was presented on voir dire. Have you gone back to the transcript to look at that?
I don't have
Okay,
the.
I have.
Okay.
The names, they were called by number, but at sidebar, they were identified by name. So this is not an anonymous jury here.
That is correct.
Do you agree that if it is to be an anonymous jury, so that the names are not known, there would have to be a burden on the burden of showing that that this jury should be anonymous, some showing that would justify the anonymity of the jurors?
That's right. Commonwealth v. Angiulo, I think, is the case that talks about anonymous jurors, and they're frowned upon. And, you know, jury trials are public and open to the press, and there is no way that what the judge here did was make this an anonymous jury trial.
Of course, you know, the only reason why there's anonymity in 2014 is because cities are as big as they are. There was a time when you know, everybody knew who was on the jury just because we knew everybody in town.
That's correct.
So 200 years ago, or 100 years ago, maybe even 50 years ago, it was no secret who sat on a particular case.
Your
In fact,
Honor, I don't think it was a
it could
secret
even
in-
be a matter of social stature.
I understand, but honestly, Your Honor, I don't think it was a secret in this case as well. I just think the judge did not provide the Globe with the list and the addresses when they wanted it. But to say that this jury, the members of the jury were secret, is not an accurate representation.
But how does one find out who they are?
Well, Judge Gantz went back and looked at the transcript, and he saw that the name.
Was at sidebar, so maybe if there's a transcript prepared sometime in the future, maybe all of that will be available,
Right.
It's not
is
going to
that-
be available the day after the trial's over.
or
to
any
be
time
sure.
near.
Or you could ask for the court reporter, if that would be possible, as a reporter, if you're sitting in.
So in those
luck.
instances where perhaps the names were mentioned at sidebar, which
Yes.
would not be public,
That's correct.
you're saying if the press knew that actually the names were used, then they could go to the stenographer and try to get some sort of expedited transcript of that?
They could ask. I mean, I'm just throwing out a suggestion of other alternatives for making, it's not a secret. What I'm saying is these jurors are not anonymous.
So they're not anonymous, so why shouldn't the press be provided with the list that the court keeps of their names?
Well, this court has only assumed without deciding that it's a judicial record. And there are circumstances when this court has indicated that there are reasons why.
So your view is, let's make it as hard as possible, even though we have the list, let's make it as hard as possible so the press normally won't pursue it.
No, Your Honor, actually, my view is the opposite. I mean, the judges have a discretion whether or not to make it available in the form and manner that the press wants it. And here, Judge Laureate, in a thoughtful analysis, weighed what he thought were the jurors' privacy interests against the press First Amendment rights, and decided that he would ask the jurors first if they would like to speak to the press. I think that, you know, jury trials are presumptively public. It instills confidence in
It
our
does.
jury system
But-
for it to
but-
be public.
The juror's privacy, and I guess that's where I'm having some trouble, is why that's the appropriate balance. The judge's perception of the juror's privacy interests versus a common law right, First Amendment right.
Well, in this
to-
case,
to-
Your Honor, the judge did ask the jury, but
Now,
they had already been
I
discharged.
understand he asked them, but, and they said, we're not interested. But that's still the question of why that becomes the determinative factor when you are balancing. I don't understand why that should be.
Well, here, the jurors were discharged, and the judge thought that they should have the ability to resume their private lives without interference from the press. So he wanted to give them the option.
You say interference sounds like such a negative thing, without the possibility that they might be contacted to see if they had a comment about their jury service. That's interference with their lives?
Well, in some circumstances, Your Honor, it could be if people are repeatedly calling you and asking you questions about something you don't choose to discuss. Here, I would
I
point out
have a
that
lot of that, actually.
2 jurors actually did respond yes, that they would be willing to talk to the press.
Now, you realize that if you prevail, one of the consequences of all this will be in a publicized trial, the press wanting to be present for voir dire,
Yes.
and possibly some negotiation then with the court as to the availability of jury names as an alternative to the press being present at voir dire. That would be a likely consequence if you win.
I understand that.
Is that a good, so they get the names right away? Do we want that? I mean,
So they might be bothered during the trial.
which has a whole lot of other risks.
Well, there are cases that say the jurors' names should be kept quiet until the end of trial. So let's just say the voir dire is transcribed, and then after the jury comes back with a verdict, the transcript of the voir dire is
That's about a
provided
year
to the
away at the
press.
moment.
I'm sorry?
That's about a year away at the moment. Now, maybe that's going to change, it should change, but it's not.
Right, but I mean, when we're talking about ways to get around disclosing the names of the jury during the trial, you can say, at the end of the trial, when the verdict has been returned, you can make a motion for an expedited motion for the transcript of the voir dire.
But aren't you back at the same place? I mean, in this case, on your theory, it would be fine for the judge to say, you can make the motion, but I'm going to deny it because I've asked the jurors and I don't think they want to talk to you, right?
No, Your Honor, that's not what I'm saying. He asked the jurors and they indicated they did not want to talk to them.
That's what I said.
But they indicated they
But I
didn't
mean,
want.
why would he, I guess all I'm saying is, they can make a motion to get the transcript, right?
Yes.
Doesn't the same factors, in your view, come up? Does he grant the motion for the transcript if he's asked the jurors and they say they don't want to talk to the press? So why should he give them the names?
No, I don't think the same motion, I don't think the same issues come up. The press will have to go through the transcripts and get the name of the jurors and the addresses. It's not the judge providing, I don't think it's the same balancing test.
Is that because it's a part of the trial proceeding and that is presumptively public?
That is true, Your Honor, yes.
And that's Press Enterprise 2,
Yeah.
where the judge refused to release the voir dire.
Right.
But that requires a much higher burden to prevent that from being released.
That is correct.
All right, counsel, thank you very much.
Thank you very much.